I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my Geofentastic co-host, Brett.
That's great, Alice. That's another wonderful pun / totally made up word.
Totally made
Alice.
Up word. But get it? Fantastic? Like fence instead of fantastic? I'm going to stop explaining my joke.
Yeah,
I feel pretty good about it.
You know what I love about that? I love how much you loved it. That's what I love about it.
Thank you. Today has been one of those days where I truly, no sarcasm, have been looking forward to sitting down with you, Brett, and talking about the Fourth Amendment and geofence warrants. So this has been maybe the most normal part of my day, and I've looked forward to it. So this is my fun time of the day.
Yes, this is our fun time. Talking about the nerdiest possible subjects. Constitutional law and its interaction with search warrants. But this is something a lot of you guys really love to talk about. And geofence warrants, they've been kind of the hot thing. They show up in all the big cases. We see them in Long Island serial killer. We see them in Delphi, out in Idaho, just all over the place. It's a tool that police use more and more to try and identify suspects. So it's a little different from your typical warrant. Typical warrant, you sort of know who you're looking for, and you use that to figure out what you want to find, right? Like, the guy and you want to see if the gun's in his house, or, you think he's got this stashed away in his shed. And so you want to search that place. But the whole purpose of this is to help law enforcement identify possible suspects. In some ways, it's kind of like genetic genealogy. It has a similar type flair to it where, there was a crime and you have a pretty good idea that you have evidence that would tell you who it is that committed the crime, but you need to get it. And one really interesting question about both those things, genetic genealogy and geofence, is whether you even need a warrant. We're going to talk about that today, and I think you guys will enjoy this. And we're going to talk about the Fourth Amendment a lot, over the next few months or so. I mean, we're trying to sprinkle in this stuff in between talking about specific cases and that kind of thing, because we do love to do the whole Prosecutors University thing, and I think you guys enjoy it too.
And so when we talk about warrants, it's because there's some right that you have that the court needs to essentially find a reason to override that right. So what is the right that this is all rooted in? It's the Fourth Amendment found in our Constitution. So what is the Fourth Amendment? It's the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. It shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. I just read all of that Fourth Amendment to you, but it describes exactly what the warrant process is. So essentially, we, as kind of free citizens of this country, are supposed to enjoy a certain level of privacy from unreasonable searches and seizures. Seizures being taking things away from you. But that is not an absolute right. Obviously, when you submit yourself to a government, to a society, there's going to be limits between kind of the private rights and the public rights, especially when there's a potential crime that has been committed. And so the second part of the Fourth Amendment is essentially saying what you need in order to override this presumption that you get to have privacy in your personal effects, right? That the papers thing are your things. The houses is your also like your castle, right? We've talked about this with other kind of Supreme Court interpretations of what is your castle. Is your car your castle? Because cars, didn't exist when the Fourth Amendment was written. But houses, and the idea was places that you can kind of enjoy your privacy and freedom, free from the big brother eye of the government.
And that's the way you often do this sort of thing. You're always looking at analogies because the Constitution is meant to endure. and it is not limited to the technology at the time or anything along those lines. So the fact that there were no cell phones doesn't mean you have no right in your cell phone. What you have to do is look at the rights that you had, what they applied to, and you sort of argue by analogy. Now, look, we could spend an entire episode just on the Fourth Amendment, just going through the text of the Fourth Amendment. A couple things that should immediately jump out to you. Number one, it does not say the right of the people to be secure in their persons, houses, papers, and effects. There shall be no searches and seizures without a warrant. It doesn't say that. It says you're protected against unreasonable searches and seizures, and then it tells you under what circumstances a warrant can issue. We're going to talk about that more, about what is an unreasonable search and when does a search become a search that actually implicates the Fourth Amendment and then requires a warrant, because there are searches. In fact, there are a lot of them. And there's a lot of information that the authorities can get from you, you don't even know it, that do not require a warrant. So we'll get into that. And then the second thing is you have this probable cause. It has to be supported by oath or affirmation, and that is the way it is to this day. When you're going to get a search warrant, you have an officer who fills out an affidavit that lays out the probable cause, the reason that you suspect that in this place at this time there is going to be evidence of a crime. And you have to swear to that as the officer. The officer has to swear to that, and only under those circumstances can you get one of these warrants. Now, the point of this, it was meant to protect against so-called general warrants. So before the Revolution, the king could grant general warrants that allowed royal agents to stop anyone they wanted and search their things, whether or not they had any reason to believe this person was involved in a crime. And that was a general warrant. And it was sort of a way to maintain order, because if you could be stopped at any time by this royal agent and searched, the idea is you're probably going to stay on the straight and narrow. In some ways, this is sort of, it's light terror, right? So, a lot of, and I'm not going to say the British were a dictatorial regime or an authoritarian regime. I don't think they were quite that bad. But if you look at sort of the way the Stasi in East Germany operated, or the Gestapo, or the Russian secret police, or anything like this, there's always this subtle pressure. In addition to the overt, horrible things that you see out in the public square, there's this subtle pressure that at any time, if you step out of line, you could be punished.
And you can see how when you have general warrants, it really kind of eviscerates any sort of privacy in general, because you don't have to have done something wrong to be stopped, right? We are so conditioned to know about the particularity of being stopped and having our Fourth Amendment rights impinged upon, that in just about any situation where someone comes in contact with a police officer, what's kind of the first thing that comes to mind? That person will say, "What'd I do, officer? What's the problem?" Right? Because there has to be a problem. There has to be a reason for that police officer to essentially be questioning you and beginning down this road of impinging upon your privacy. But that's removed if you just have this general, like, you exist here. And so, this is kind of like what happens in a household between parents and children, right? Like, I do get to search my kids' rooms anytime I want. They don't have that sense of privacy when they're like, 3 and 4 years old, because they hide things like matches in their room. That's a very...
Same thing in a prison.
We're in prison.
Right?
Absolutely. Those are very different situations than what we have grown accustomed to in general society outside of the strictures I just explained, because of our particularity requirement, which is directly kind of opposite of where we came from in England.
And it's interesting, Alice was talking about how the police can't just stop you for no reason. This actually came up in sort of a hilarious way, where the police, they were pulling people over to tell them they were driving well. They would like pull them over, and they would give them like a coupon to get breakfast somewhere, instead of a ticket, to encourage safe driving. They were sort of like, and there was this nice local news station did a show on this. And then somebody was like, yeah, that's totally unconstitutional, because the police can't just pull you over for no reason. They have to have some sort of articulable suspicion and probable cause that a crime's been committed, like you're speeding or your taillight's out or whatever. They can't just stop you. So if they're stopping you to tell you what a good job you've done, they can't do that. I had in the case, I think I mentioned this, where the police wanted to get a search warrant to rule somebody out. They really didn't think they were involved in the crime, so they wanted a search warrant just to like be able to say for certain. And I was like, you can't get a search warrant if you don't think you're going to find anything. That's not the way it works. It has to be that you actually are looking for some sort of evidence of a crime. So it is very different from what you would have experienced in the sort of pre-revolutionary times and what a lot of people experience today. I mean, there are a lot of countries we consider to be very free that can stop you and sort of the old, papers, please type thing and do pretty much whatever they want. That is not the case in the United States. And preventing these, they called them the evil writs, was one of the many reasons for the revolution. And preventing them was the primary inspiration for the Fourth Amendment. And this notion of particularity, of specificity, these are the responses to this. If you're going to have a warrant, it can't be a general warrant. It has to specify where and when the search will occur and what specifically the police will be looking for. And you have to show probable cause that this search is going to result in finding something. Can't just be a hunch. Can't just be, that guy looked at me wrong. Or, he seemed too nervous when I walked by. I mean, those are not reasons that you can get a search warrant. You have to have probable cause, and it has to be pretty thorough. And sometimes for some warrants, like a wiretap, you'll see affidavits that are 100 pages long. I used to hate having to read those. It was it was interesting because you learn everything about the crime, but it's a 100-page affidavit laying out all the reasons why this wiretap is necessary and proper, because that's a pretty big impingement on your privacy. And that's another thing. Not all searches are the same. A search of your home is going to be much different than a search of maybe an area where your privacy interests aren't quite as high.
So there's the particularity requirement. But before we get to the question of whether a warrant is sufficient, you first have to show that you have a privacy interest that is implicated by a search. What are we talking about here? That interest has to be yours, and yours, not somebody else's. You can't stand in the shoes of another person. So, for instance, if the police violated someone else's privacy rights and find evidence of your crime, you actually can't move to suppress it. So, for example, let's say that Brett gets stopped, for absolutely no reason. He's standing on a street corner minding his own business, and a police officer goes up to him and starts frisking him completely illegally. And in his pocket, he finds my note to Brett saying, "I'm going to rob this bank." Brett could not have been searched. There was no probable cause for that search, but they did. I, as Alice, even though my note was in his pocket and it was found during that illegal search, I can't move to suppress that illegal search because I'm not the one who had my Fourth Amendment rights violated.
That's right. And, it's not a vicarious right. You cannot assert it on behalf of someone else to prevent evidence from coming in against you. Even though you have an interest because the evidence is coming in and that's against you, and that's a problem for you, but you can't point to a search that violated your rights. And you can only advocate for your rights. The same way, if I search your house illegally, I search your house illegally, and I search Alice's house illegally, and I find nothing in your house. But when I search Alice's house illegally, I find something that implicates both of you in a crime. Well, Alice can move to have it suppressed because there's a search of her private area that results in evidence against her. The evidence that was found in her house can still be used against you, even though there was an illegal search of your home. The two things have to go together. So you've all heard of fruit of the poisonous tree. Like, your tree bore no fruit. Even if your tree was poisonous, there was no fruit that came of it because when they did the illegal search, they didn't find anything. So the fact that this evidence was found somewhere else, you can't connect the two together. Like, well, I had an illegal search and there was evidence found against me in a different illegal search, so therefore that should be good enough. You can't do that. It has to be that you were in a circumstance where evidence was found against you in a search that violated your rights. You can then say, this needs to be excluded in order to protect my Fourth Amendment rights.
And this isn't unique just to the Fourth Amendment or criminal law. This is something that is kind of the core principle within all of law. When we talk about standing, we've talked about standing before, that you can't assert someone else's rights. This is just another version of standing, right? And by the way, this does actually come up not infrequently in our cases. You can imagine someone's car, it's not the defendant's car, is searched in another instance, and there, evidence of, drugs or drug paraphernalia or guns that they shouldn't have were found there. We've also seen searches of hotel rooms or houses that don't belong to the defendant, but that they are implicated in some crime there. So this actually does come up a good bit, and they do try to bring these suppression motions, and typically they should be defeated because it is not their right to assert. But this kind of leads us into the third-party doctrine. When you voluntarily provide your information to a third party, think about your apps, your phone, the car you drive with a GPS, you lose your privacy protections over that information. What one knowingly exposes to public scrutiny is not subject to the protections of the Fourth Amendment. Does this sound familiar to a previous legal briefs? Remember when Taylor Swift's attorney wrote a demand letter to the person on Twitter, X, who was tracking all of her flights based on public data? What did we say there? That was public information. She didn't have a right to have that information somehow not be discussed in public. Same thing here. So the whole idea is it's not private if you are broadcasting to the world. When you can check in on Facebook, for example, and say, I was at the Crab Shack eating delicious crab cakes out of a crab shell. That's so fun. Well, you've already told the world. You don't get to say, I get to show the entire world except for law enforcement. So the idea is it's already out there for public scrutiny. Now, there's a narrow exception to this rule, and that's Carpenter. So this was a Supreme Court case that said months of cell site location information, shorthand is known as CSLI, required a warrant to search. Now, what did I just say? I was like, if you give your information to cell phones, well, that's interesting because you are giving it to a third party, whether it's your, T-Mobile or AT&T, whatever provider you're using. That's not the government. You're giving them access to all this information. So how does this fall outside of this general idea of third-party doctrine? So the Supreme Court said cell phones are necessary for daily life. This came out in 2018, so that may not have been the case in 1960, 1970, when there were no cell phones, but today they are a necessary part of daily life. You use them to drive and figure out your map situation. You order food from it. You do online shopping. There's so much that we do on our phones that essentially it's an extension of ourselves. And the court said that you couldn't opt out of the cell site location information because it's necessary to the phone to operate. They further held that because it was so invasive, following you every moment of every day, that the court said this type of information didn't fall under the third-party doctrine. Instead, you did have to get a warrant for this information. But the court did limit Carpenter to its specific facts and its narrow holding. Carpenter doesn't even prevent law enforcement from obtaining days' worth of CSLI without a warrant. We see that in situations of like kidnapping, for example.
Yeah, everybody's pretty certain you can get at least 7 days. Some people can get up to 30, just depending on who you ask. But Carpenter is the exception that proves the rule. It is the case that every defense attorney and every person who ever wants to challenge anything will cite. Because they're always like, but Carpenter! Well, yeah, the fact that you're having to cite Carpenter basically proves that your argument fails. Because Carpenter, you had a situation, if I recall, I think they had 128 days of CSLI for this guy. So they pulled 128. I could be wrong about the exact number, but it's a lot. And for those 128 days, they were able to follow that guy everywhere he went for the entirety of that time. And the court, it was one of those where it was just, and this is a good example of stupid decisions by investigators making bad law. They should have known that was too much. They should have gone ahead and gotten themselves a warrant just to be safe so that we wouldn't have Carpenter. But because they pressed the boundaries on that and went ahead and did that, you end up with the Supreme Court in a position where they're like, I don't know. Now, look, Carpenter, I think it was 5-4 or 6-3. It was pretty close. And based on how the court has changed, I don't know that Carpenter would go the same way if it happened today. But at the time, the court was like, look, it's just too much. We just can't accept this. But they made clear there were all sorts of reasons to limit it. You know, One thing, for instance, as we get into geofence warrants, geofence warrants, for those of you who don't know, is basically Google, our overlords at Google, in addition to seeing everything else it does, has mapped essentially every Wi-Fi hotspot in the world. I think they're up to 92 or 93% of Wi-Fi hotspots are mapped. And those include the ones in your house. So the car, when you see the car driving around with a camera on top, updating the map, taking pictures, you're like waving at it. Maybe I'll be on Google Earth. What it's also doing is searching you to see whether or not you have a Wi-Fi hotspot on you, where there's one in your car that you're in, where there's one in your house that's broadcasting. They map all of these and they get the coordinates of them. Then when you use an Android phone, or in very rare cases, an iPhone with a Google app, iPhones, there's a reason we call these, these are geofence warrants. They're Google geofence warrants. They really only apply to Androids and Google applications. Apple, for all of its faults, is better on privacy than Google is. Some of us might say that Apple protects criminals with more vigor than Google does. But in any event, Google's mapping all these things. When you go to a store, for instance, when you whip out your phone to look and see, where the hammers are in Home Depot, and it's like aisle 3, and it's so helpful, and you go to aisle 3. Well, when you did that, Google recorded the fact that you were there. It recorded the fact that you were connecting to that Wi-Fi hotspot. And then what can happen is, say Home Depot wants to do some sort of ad hoc coupon for everybody who visited their store on Saturday. They can call up Google, pay them a fee, and say, hey, can you send us everybody's information that was in our store? They get all your information, then they can send you a coupon, and then you can go shop at Home Depot and wonder, how is it Home Depot knew that I was there? Well, that's how they do it. And so Google has, at its headquarters, information for everywhere that your phone is connecting as you travel around the world. The difference between this and CSLI is, you may notice when you open up your phone and you hit an app, what comes up the first time you do it, and maybe subsequent times. Share location data with Google, and there's always, just when I'm using the app, or never with this app, and you pick, right? Well, if you pick one of those two up top, that information is now going to be with Google, and they're going to have that information, and they will be able to share it with anybody they want. And that includes the police when they come looking to find out when that Home Depot was robbed, who all was in that area at the time of the robbery.
And some of you may be thinking, okay, how can I get around this? Easy. I'll just have an iPhone, not an Android. Wrong, because it applies to any app that uses Google products. And at this point, Google doesn't just own Androids. I have an iPhone. I also have a Google browser on it. I also have Uber and DoorDash and other apps that utilize Google Maps, which all sync up to Google. And so while, yes, you could have an iPhone, it would probably be a bit difficult to operate your iPhone absent of any sort of app that touches upon Google. And I mean, so I was having a conversation with someone working in counterintelligence, and they basically told me, they were like, you have no idea the extent to which you are wired, even more so than you know. And I'm someone who applied for geofence warrants. I'd like to think of myself in like the top 1% of understanding just how connected and just how visible all of my movements are. And they were like, unless you find and drive a car that is pre-2010, every really moment of your life is mapped out for someone to be able to find. Not necessarily the government. The private sector is, the reason this exists is because there's money to be made in this. The government knows that private companies have access to this information, hence the need for warrants. So don't blame necessarily the government on this. This all exists for profit motive.
And you guys remember the Murdoch case. I mean, the telematics they got, when we had Jay Burney on talking about some of this stuff. Their ability to basically say, Murdaugh, he pulled his car around this way and he opened his back gate at this time and his passenger side door opened at this time. I mean, they have the information that they can gather is almost unlimited. And, you And this is the eternal question. And when you go to law school and you take contracts class, the sort of sticky ultimate question that you're always faced with by your professors is the question of these contracts of adhesion. So basically, those documents, whenever you do anything, you go skiing or you buy a car or download iTunes, whatever, there are 27,000 pages of tiny print written in legalese that before you can use the thing, you got to click a button at the bottom. And literally no one reads it, and everybody knows no one reads it. But when you do that, you are agreeing to give up all of these very important things. And how effective are those? How effective should they be? Like, should we allow you to, Google to essentially, in order to use Google Maps, which is basically a necessity of life these days, right? Try and find anything without Google Maps. The good old days are gone. I can't find anything now.
You see just how people are reliant on Google Maps. We have all these stories of people driving off bridges to their death because they followed Google Maps to literally their death, right? People trust Google Maps over their own memory or their own eyes, really, of the roads that they're in front of. That's how integral it is to everyone's life. And then think of all of the location data services that are embedded in other apps that you may not be thinking about. They're all tracking your location.
And the Supreme Court in Carpenter, although Carpenter remains very much an outlier, nevertheless, it is the first indication of a court attempting to grapple with a dramatically different circumstance than we've ever had before. And they cite another case that was talking about cell phones that said, if aliens came down today and saw us, so ubiquitous are cell phones that they would assume it was a part of our anatomy. And it's true. The most terrifying thing you can do is turn on the usage monitor on your phone. And it gives you that, your 7-day look back over how often you used your phone. And it's basically, unless you're asleep, your phone is on and in your hand. And there is this question of just how liberally should we allow this kind of information to be used by the police or by a company.
And then the flip side, of course, is that this is a treasure trove of information for law enforcement. This is the information that could literally mean life or death for a child who has been snatched. And each minute that passes by could mean a minute closer to disaster for that child. It could mean finding otherwise completely unfindable people, whether it's because they're in the wild or in places that are just seemingly unwired. I mean, it is incredible information for law enforcement. But we also have the Fourth Amendment, and therein lies kind of the tension of all of this.
And this goes back to that reasonableness question. And one of the things the Supreme Court and all the courts have routinely said when interpreting that part of the Fourth Amendment is, the question is, what amount of privacy is society willing to give up to live in a society and to be able to deal with these kinds of issues? It's Benjamin Franklin said, he who would give up liberty for security deserves neither. And that was powerful. Love Benjamin Franklin. Great line. Totally impractical, right? That's what we call government. Government is giving up liberty for security. That is the whole point of government. So the question is not, are you going to allow this at all? And so what extent are you going to allow it? And I will say this for Google. We're knocking Google. They're invading your privacy. Pretty much everybody, at least up to this point, believes that you don't need a warrant for a geofence. That you can just get a subpoena, send it over to Google and say, hey, I want this information at this time, in this place, who all's phones were there. And
really quick, the difference between a subpoena and a warrant, we've said this before, but just in case you don't know, a warrant had to have all of those. You had to have an oath, affidavit, supporting probable cause. A subpoena is a court document that's essentially stamped by the court, just saying, turn over this information. You may have received a subpoena before because you had relevant information to a neighbor's divorce, for example, something like that. So a subpoena doesn't have to make a showing. It's simply, we think you have information. You have to respond.
Yeah, and you have to. You're compelled to respond. On penalty of law, on penalty of going and put Google in prison if they don't comply, or more likely fine them or something. So everybody pretty much believes that you could just subpoena this information. Google has said they're not going to comply with these subpoenas. that they will only turn this over if you have a warrant. So Google has taken sort of an additional step. And law enforcement, not eager to get into a court fight with Google, which may have just a little bit more resources than your average police department or even federal agency, has complied and said, okay, fine, we will get you a warrant. And the Geofence warrant was born from that. It is a compromise between law enforcement and Google, where law enforcement won't seek this just by subpoena, but will get a warrant to get the information.
Sometimes there's just so much to talk about. Okay. So specificity and particularity are met. Remember, we talked about that. That is required in this warrant. They're typically met when you say, I think there's going to be, drugs, drug scales, whatever in this drug house. And that's what I'm going in to search for because I have these reasons to believe why there's going to be drug paraphernalia in this house that is suspected to be a drug house. How do you do that when you're asking for like geofence information, which is really a pool of everyone who is in this area? Well, specificity and particularity are actually met by specifying exactly where will be searched for specific times for particular information. So say there's two locations. One's the site of a robbery that occurred, and the other is the site of a possible getaway car at a specific time. Maybe you know exactly when the robbery occurred and when the car drove off. And a few minutes later, so the time of the robbery, and then a few minutes later at the site of the getaway car, and maybe to open that up just a little bit beforehand and then a little bit after. That, how much before and after, is up for debate with particular judges, but you better be pretty specific. Remember, Carpenter, we got there because we were a little too liberal with our times. And then you have to ask for particular information. So the devices in both areas at the relevant times. That's how you get to specificity and particularity for a geofence warrant.
And, and I'll just tell you how this goes. It's a 3-step process. So Google has, not only does it require a warrant, but it takes these extra steps to protect the privacy of people who aren't involved. So let's say you've got these 2 areas and these 2 times, you want the geofence warrant. And you send that up, you get a judge to sign off on it, you send it up to Google, right? And you may be asking yourself, how do you know that the robber had a cell phone? I mean, that's a good question because we're searching for cell phones here. What is there to lead us to believe the robber's going to have a cell phone? Well, the same reasoning that led to Carpenter leads to that. Most people have cell phones on them. Even criminals tend to carry their cell phones with them when they commit a crime. Now, they're getting a little bit better about that. You're seeing people be a little bit more likely not to do that. But then maybe they have an iWatch or whatever it's called, or any number of other devices that are actually connected to Google products that they may not even think about. So the chances that a Google product is broadcasting in some form or fashion are pretty high. And remember, you don't need certainty. You don't have to say, we're 100% certain there was a cell phone there connected to the robber. It's probable cause. So you just have to make a showing that it's not even more likely than not. That's higher than probable cause. And just that a reasonable person could articulate why they believed that this would be the case is essentially what you're looking for with probable cause. So you're going to be able to do that. And so then you say to Google, okay, I want everybody in this area. And as Alice said, you have to keep the area relatively small, and you have to keep the time frame relatively small. And you have to do that for 2 reasons. Number 1, the judge. But number 2, Google. Because Google can only do so much. This can turn into a massive output of information. So much information that it overwhelms their servers. So Google will want you to keep it relatively small. If you're doing a geofence warrant over the middle of downtown New York, over Times Square, or somewhere like that, you're going to get so many devices. Number 1, the information will be worthless, and number 2, it'll be hard to do. But anyways, Google pulls all those numbers, and then they anonymize them. So they anonymize them, and they send the information back to the police. And then the police, and usually it's the FBI, usually it's people like Jay Burney at CAST, they take a look at those anonymized numbers, where they were at various times, and they look for which are some that are in all the places we want them to be at the time we need them to be there. And then they pick out those, and usually it's very few. You're getting hundreds down to 2 or 3. Once you've done that, you send it back to Google with an explanation, and then Google will unmask those. And then you'll know those 3 devices that were in your area at the time of the crime, and that is a lead that you can then use to continue to investigate, to figure out if any of those 3 people were actually involved in the crime.
So that 2-step process, as you can imagine, is actually, it's meant to be further filters to protect this information, right? Like there has to be a second showing as to why the information has to be unanonymized. And we use this a good bit, and they are helpful as leads sometimes, not always, because it depends on the location. A very rural area might actually be better because there are fewer devices in the area. You may be able to hone in, but if you're in a really busy area, you might have so many leads that they almost wash each other out. But I've always thought the 2-step process was good in terms of protections for the Fourth Amendment, because there are times in your investigation where weeks pass by, every day, especially if it's a hot case, there can be a lot of developments. And you may get to a point where you don't need to seek the second step of the geofence warrant to get information if your investigation has proceeded so that you no longer need that lead because you think you have who you have. That's good. That means the government never got the unanonymized information, and the need for that information fell away. The negative, of course, is that if you have no other leads and there's someone dangerous out there, this is taking longer to get the information for a potential lead and a potential arrest of someone who could be dangerous and doing whatever they did again.
And the other thing is Google will warn you that it's not foolproof. It's not perfect. You're not going to get everybody. And, sometimes you do a geofence warrant and you're just convinced the person is going to show up, and they don't show up. And Google's like, look, if the signal's not particularly strong, if the connection's not that good, it might not record it. If there's too many connections, all of them might not get recorded. So it's not perfect. It's not this all-seeing eye that it may seem like it is initially. It's really good. And, usually if you have somebody who's actively using an app, they don't have to be, but if they're actively using an app that is connected to Google in an area with a relatively strong signal, they're probably almost certainly going to show up. If the app's running in the background, they're probably going to show up. If the app's running in the background, but it doesn't have a great signal, maybe. If the signal's really bad, who knows? It gets less and less effective depending on how far away it is. I mean, how it is, like sometimes you look at your phone and you're trying to get a Wi-Fi connection, and you hit the Wi-Fi button and it shows you a bunch of different connections. You try to connect to one, it won't connect to it, and it refreshes and half of them disappear. A lot of times the connection's not actually there. You're not actually connected the same way if you're in one of these difficult places. So it's not perfect, but it's pretty good. Now, once again, there's this notion out there. Geofence warrants feel scary because they're new and different. And this notion of Google sort of watching you and how easy it is for the government to get this information, it feels scary. But the thing is, there are countless examples of law enforcement tools that provide the kind of data, or even more, where you don't need a warrant at all. Remember, we got Google requiring you to get a warrant, requiring you to jump through all these hoops, only giving you an anonymized data to begin with, requiring you to narrow that down, and then telling you 2 or 3 people in the area. Or you can get a cell tower dump, which only requires a subpoena. You send a subpoena to whoever owns the cell tower, and they give you every single person connected to that tower at that time. And they give you everything. There's no anonymous.
There's no anonymizing.
There's no anonymizing. There's no calling people out. They just give you the information. And you can kind of think of this, if you think about the geofence warrant and the tower dump, think of it this way. Your cell phone, little mini computer that has every piece of information about you, more information about you than any diary you could write. In order to get into that, you have to have a search warrant. I cannot look at your cell phone without your permission unless I have a search warrant, unless it's a super exigent circumstance. I'm going to have a warrant to look at it. To get the location of your phone, to get the thing that isn't in your phone but is being broadcast out at that moment, doing that tower dump, I can get that with a subpoena. Same thing with your Google account. In order to get into your account, to see the information in your account, to read that stuff, I need a warrant. Now, I need a warrant for your geofence too, but put that aside. I need a warrant, and the courts say I need a warrant to do that. To get your location, I really only need a subpoena. I need a warrant because Google makes me, but your location is just something for which you have less privacy interest. And why is that? Well, one reason is because you're out in public. It would be different, and it's always different, if the government is reaching into your home. One of the things about the CSLI was they talked about how you take your phone everywhere into your home, to your mistress's house, to your secret political organization you belong to that you don't want your friends to know about, to various other places where you expect privacy and really want to have it. That is too much. And that's one of the reasons that CSLI was a problem. Usually when you're doing a geofence warrant, almost always, you're doing it over a public location. You're doing it over the site of a robbery, the site of a kidnapping, the site of a murder, somewhere that anyone out there looking, if they could see you, that's enough, right? You don't have a right to privacy in what people can see. For instance, if I want to know whether or not you were in the parking lot of the convenience store, the other thing I could do is subpoena all of the video cameras that are looking at the parking lot and get not only your name or that you have a Google account, but get your face, what you're wearing, what you're driving, who you're hanging out with. I can get all that information too. In fact, usually the reason we know the location to use the geofence warrant for is because we've already pulled those surveillance cameras and we see the individual in the various locations. We see them at the robbery site. We see them running down the alley. We see them getting into the getaway car. And so we pick those 3 places and we say, boom, 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 these times, these places, give me who was in that area. And you're able to turn that into more information. The other thing, bank records. I mean, people are always surprised by that. Bank records.
This is kind of crazy that bank records don't need warrants.
Credit card information.
Think about the transactions. When I look at my transaction statements for the last month, it's like a diary. I can't tell you where I ate lunch last week, but my credit card statement sure can. It can tell you all the places that I went, at what times. It shows you my patterns, like, oh, I get coffee in the morning. What time do I get up in the morning? There's no transactions after a certain time at night. Is that when I go home for the night? I mean, it is a really, I would say it's closest to a diary as your cell site location. Yet, that doesn't require a warrant whatsoever. You just get subpoenaed for your bank records and they all turn over, and the bank doesn't have to tell you for a certain amount of time that they have turned it over if it's in response to a criminal investigation.
Yeah, I mean, you can see exactly how much you spent at that adult novelty store and
where you paid dues with
where you
a political
dues.
organization
Exactly.
or a nonprofit.
Yeah, I mean, all sorts of stuff about you. License plate readers. Do you guys know about license plate readers? When you're driving down the road and you don't know it, we're taking pictures of your license plate. And if later on we want to figure out who was driving down that road at that time, we just pull it up. There's your license plate. We know exactly who you were and exactly where you were going. None of these things require a search warrant. None of them. They are all things that you can get with a subpoena. And this goes back to, not to bring the genetic genealogy back into it, but just how silly some of these things are. The amount of information, like I can have one like quintillion of your DNA because I have the DNA of your 27th cousin. Or I can have the records of everything you did yesterday, everywhere you went, every dime you spent, everybody you saw. I can have all that with just a subpoena, with just an order to the person who has it to give it to me. That's all I need. The things we fight over these privacy interests sometimes only because they're sexy, only because they're different or new. And we don't even think about all the areas where already you just don't actually have much of an expectation of privacy. And whether you should is a different argument. Whether all the things we just listed should be things that the police, law enforcement can access basically for no reason at all other than there's a crime that they're looking into. That's a different question. But the fact is, right now, they can do that. So when you're looking at someone who's arguing that, we shouldn't be able to see what you Googled, or we shouldn't be able to see the geofence warrant or whatever, just realize how incongruous that is with everything else in the law when it comes to searches.
So maybe we scared you tonight rather than convincing you that geofence warrants are not that invasive to your Fourth Amendment rights. We've actually scared you into realizing a lot of information is turned over. Now, of course, there are protections to that information. It's not just published on some public database. They're supposed to only be used in the course of an investigation. All of those things. But of course, when there's information, there is potential for abuse. And it's helpful to know what your rights are, first of all, what the Fourth Amendment says about those rights, but it's also helpful to know what type of law enforcement tools are used. And before you say, shut it all down, no more subpoenas for anything, you probably won't be saying that when all investigations are essentially hampered and completely shut down, and the ability to make arrests or solve crimes falls to zero. Because these are law enforcement tactics for a reason. They are incredibly useful, and yet still, 50% of murders go unsolved? So while these are incredible tools, they also have limitations to them. And this is something that is worthy of discussion, which is why we're talking about it today, to know what is available for law enforcement purposes, and to also recognize that if you were to take them away, what you'd be giving up.
Yeah, I mean, I think it's important that everybody knows the law, but I think it is very important. And one of the reasons I think it's important to know the law about this is because there's so much fear mongering about new emerging technologies. And I know we're talking about geofence warrants. Geofence warrants, it's kind of pointless when we're talking about them. They're going away because Google is changing the way they store this information. They're moving the information out of their servers and onto your phones. So your phones are going to have all this information, but Google claims that they won't be in possession of that information and therefore will not be able to provide it.
And by the way, the reason they are doing that is because it is so onerous for them to provide these geofence warrants information because of the sheer number that they get. Almost any criminal investigation that needs a geofence warrant, think about how many hundreds of thousands of requests they get. I mean, I've spoken directly with geofence warrant responders at Google when we're working with them on geofence warrants, and this is all they do. 24 hours a day. It is a huge burden on them. And so they're moving it to your phones, or so they say, precisely in response to geofence warrants.
And look, I mean, maybe you're out there cheering, but just know the next time you see an Amber Alert and some kid's been kidnapped, it's going to be that much harder to find the kid, because that tool that we could have used, I mean, sometimes, maybe even most of the time, you know who did it, but to identify the person is gone. And it will not be without cost because, as Alice said, the reason they're getting rid of it is because it gets used so often, because it's so valuable and it helps to solve these cases and these crimes. But the point I was making is don't get carried away when somebody, like in the genetic genealogy realm, is trying to fearmonger you and scare you into supporting legislation that prevents this information from being used because it violates your privacy interest. When, as I said, compare it to the other things and the other information that the government has access to. Doesn't mean you still shouldn't support that. Maybe you're passionate about it and you just feel like this one is a step too far. That's fine, but don't do it because you think this is so unusual and just so insane that they would even think of using something like this. No, they use this kind of information all the time, and they use information that is so much more invasive and so much more detailed about your life. Think about the cost. Always think about the cost, both to privacy and to law enforcement, to solving crimes, to preventing crimes, to giving justice, to exonerating the innocent, putting the guilty in prison. Think about the cost. Think about the balance. That is what it always goes back to. Those are the tough questions. It's always easy to rail against this stuff or to get people all worked up about it. It's much harder to think critically about it and reach some sort of compromised position where you feel like privacy is protected, but those vital public interests are also served.
Well, Even though we've talked for about an hour, this really only scratches the surface. And we hope this at least spurs some discussion. And as it's going to come up in cases that are in the news, you'll have a little bit of background as to when warrants are required, what reaches probable cause, and how they're actually used in terms of the technology. Like we mentioned earlier, we had an awesome interview with a cast member of the FBI who went into geofence warrants and a lot of the law enforcement techniques and how they're used responsibly. I thought that was incredibly enlightening. If you haven't heard that yet, I recommend you go back and listen to the technology and how it's used and how your constitutional rights are being protected at the same time. But as we always say, the more you know, the better, whether that's the Constitution, the law, and any issues with how this information can be used. But if you have questions, as always, feel free to write us at prosecutorspod@gmail.com. You can find us on social media on Twitter, X, TikTok, Instagram, Facebook. We are there at prosecutorspod. We love hearing from you. We are doing this particular show because you asked for more information about geofence warrants. Let us know what you want to hear. We would love to talk about it. Brett, with all of that, is there anything else you'd like to add before we sign off for the day?
No, do you want to do a question? Okay, let's do a question. And yes, we can talk about the Fourth Amendment till the end of time. So any follow-up questions you have or follow-up topics, let us know. We will talk about them. Okay, it's legal briefs. So all these legal briefs questions go to the front of the line. So, okay, this person has a difficult question that I don't know that we'll have any answer to. But we'll go ahead and give it anyways. Okay, this is from Beck. Beck wants to know, I've been a practicing speech-language pathologist for 10 years, and I've been increasingly interested in special education law. I'm not sure yet if going back to the school to be a lawyer is in the cards for me, but I'm curious about potential options. Are there alternative paths to combine these interests, paralegal work in an office that specializes in special education law, or would it be more beneficial to just go all in? So I would say...
I have thoughts.
I have thoughts as well. I'll go ahead and I'll throw my thoughts out there, and then you can be much more eloquent about it. I would say there are plenty of lawyers out there. There aren't as many people who have the specialized knowledge that you have. And any lawyer who is operating in this area will be very familiar with the law and how special education is implicated by the law, but they need your help. And if you're interested in being involved in the legal aspect of that, looking into being an expert, someone who testifies in cases where these issues come up. You see this a lot with whether or not children are being afforded the opportunities they're supposed to get in school. There's a Supreme Court case that is right on point here, and of course I can't remember it, but your abilities and your specialized learning could be incredibly valuable to those lawyers who are fighting for things that you care about. And it doesn't require you to go back and spend 3 years in law school to do that. Now, there's nothing wrong with going back to law school. Having dual abilities, knowing something about something other than the law can be incredibly valuable for you if you're a lawyer, but you certainly don't have to do it, I think, to find a very fulfilling role in that area of the law.
So my very first job as a high schooler was actually working as an aide to a speech pathologist. I think the work you guys do is incredible. Brett, you and I are so simpatico. That was exactly what I was going to say, was that it could be very impactful and lucrative to be an expert, and not just an expert in testifying in court. While I do think you could have a very impactful way of explaining from your vantage point certain things about maybe where the law is lacking in services. But even more so, because of your expertise and your interest in the law, you can be someone who testifies before state and local boards or legislatures or even the U.S. Congress about your vantage point and where the law may need to be improved. I'm sure that there will be sponsors of bills who would be, chomping at the bit to have someone like you with the expertise to speak about this. I just, in fact, helped edit another medical professional's speech before a legislative body on an area of law that they have a lot of medical expertise in, and the legislatures are debating, a law that is implicated by these medical procedures. And that was really, this person has a lot of interest in the law, but at this point in their career, really what they're interested in is like that area of the law not necessarily practicing in the area of the law. And so I think you have to ask yourself, is it that you want to change particular laws that you're passionate about in your state and local governments or the federal government, in which case you can jump in now, today, without having to go through 3 or more years of law school? Or is it an area that you really want to represent kids in advocacy proceedings to make sure that they get the services they want? That is a different practice than just testifying, for example. So I think some of it is what you want to do out of it. But if you wanted to get involved in special education law today, you can, without having to go through the expense and time cost of going to law school.
Okay, let's do one more question and then we'll sign off. And this one, I always enjoy this question. So what podcast, I like this. This is from Aaron, and it's a little twist on what are your favorite podcasts. What podcast, other than yours, would you recommend to your mom if she wanted to get into true crime? That's a great question because, you know, I love Big Mad True Crime with Heather Ashley. But my mom, she doesn't love the curse words. So I think she, as much as I love Heather and her perfectly timed F-bombs, I don't think my mom would love it. So I think my mom, she would enjoy the consult. Consult's awesome. She would enjoy that. I think she would enjoy Murder Sheet. You know, Murder Sheet. I think she would enjoy Murder Sheet. That'd be a good one. You know, when you look at my playlist, my podcast list are so long that, you know, my mom really likes history. So Vintage Villains, which Allison Dixon is doing, she would enjoy that because she likes the historical stuff. She would really enjoy the John Wilkes Booth episode she did recently. So those are going to be the 3 that I would say. What do you think, Alice? Do you have any to add?
Yeah, my mom doesn't listen to English things, so that would be difficult.
Doesn't even listen to your podcast. So.
She has apparently, hi Mom, apparently been listening to us on YouTube because she wants to see my face,
Aww.
Which is very sweet, but she doesn't understand the words coming out of our mouths. Which is very even sweeter because
Which
she
half
listens.
our audience doesn't understand.
That's fair.
Particularly in this podcast.
That's fair. We definitely say like, and that's why we conclude A, for sure A, unequivocally A. And then all of you write, or 50% of y'all write like, man, I had no idea they believed B.
Yeah,
and I was
really
like,
really
which
thought
part
they were
did
gonna
you
say
not understand? Which apparently is the way my mom listens to our podcast. Hi, Mom, again. Really glad you're listening. But my mom, she doesn't know this. She buys into every conspiracy theory in the world. I'm talking Yetis, aliens, everything. I say she doesn't know this because it's not like she thinks of herself as a conspiracy theorist, but she sends me like the deepest within YouTube videos. Like, I don't even know how she got there in life. Sends me these videos and they are like far out conspiracies, but she doesn't love them. She thinks they are true. So I think I'd have to send her maybe either like a fact-checking sort of podcast or just lean in and give her the most conspiratorial podcasts ever.
Yeah, I was listening to
in Mandarin.
Morning Cup of Murder. If you need guys to listen to Morning Cup of Murder. But the great thing about Morning Cup of Murder is it's short. They're like 10 to 15 minutes. So in 10 to 15 minutes, you don't really have time to get into the conspiracies. It's much more sort of just, here are the facts of the case. So maybe that would be a good one for your mom. Astonishing Legends. Astonishing Legends is great.
She's scared
they
of
love
things.
Conspiracies. Yeah.
Well, anyways, guys, these were awesome questions. Thank you. As always, if you leave a 5-star review, you can put in your review a question and we will answer it. And guess what? We really don't check. So if you kept changing your question, we'd keep answering your questions. Well, this has been fun, Brett. I always love talking about constitutional law with you and also how to investigate cases. And we will be back again to discuss something else next week. But until then, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Well, I think that's usually the case. They mark that pretty high. I know, but I went there. Well, that's smart of them, right? Because I went there for a prescription.
Oh, yeah, absolutely.
And so I was already there. So I was like, well, let me pick up some nail polish.
That's the price of convenience. Exactly.
That's the whole. It's a convenience. So you're right. But I actually was looking for nail polish. So anyways, I'm sure everybody already knows that, but like 70% off at TJ Maxx, the exact same brands, same colors and everything. Okay, that's all.
Yeah. So today on the Nail Podcast, beauty with Brett and Alice.
Anyways, I'm sorry. Okay, we can start talking about, this is actually